name is Jennifer Kuyrkendall. I'm the Third Circuit representative for the Young Lawyers Division Board of Governors. Today we have the pleasure of speaking with Kat Losey. She's going to be speaking to us about social media. Kat, thank you so much for being here today.
Thank you so much for having me. I'm really excited to be here.
Kat, it certainly seems like people are living their lives virtually through social media. Is that impacting litigation?
Well, the biggest impact that I've seen on litigation is that it's leveled the playing field in asymmetrical litigation. In this digital age, plaintiffs have within their possession and control a multitude of electronic sources that, with the assistance of their counsel, they have a duty to identify, preserve, search, and produce in discovery. And one of those sources is social media. Social media has gone from being a novelty to now becoming a mainstream form of communication. It's estimated there are about 500 million tweets sent every day, that there's about 1.1 billion Facebook users. So it's not really surprising that this form of communication has become a central focus in modern litigation, coupled with the fact that electronic discovery is a two-way street and that plaintiffs' duties, specifically involving preservation, search, and production of electronic information, apply just as forcefully to plaintiffs who invariably anticipate litigation well in advance of defendants. It's not surprising then that this has become a hot-button topic in a wide variety of litigations, ranging from criminal prosecutions to divorces, personal injury cases, and employment disputes. Social media is definitely an issue that every attorney, from the solo practitioner to an attorney in a large national firm, needs to be aware of and know how to handle.
What about privacy concerns when it comes to disclosing information from social media networking sites?
Well, courts have consistently rejected privacy objections that litigants have made when it comes to producing information from social networking sites. I'll give you an example. There's a 2012 decision from the District Court in Colorado in a case called the EEOC versus the original HoneyBaked Ham Company of Georgia. And in that case, the court squarely rejected the privacy objections that were made by the individual plaintiffs who were represented by the EEOC, because the court found that by its very nature, the social media information was more readily discoverable because it's created and shared online with others, and that this actually created a stronger argument for production. Additionally, the court characterized the creation of a social media account and the data therein as assembling an Everything About Me folder and then sharing it with others. So if everything in this Everything About Me folder is relevant to the claims and defenses in litigation, or reasonably calculated to lead to the discovery of admissible evidence, then it should be part of disclosure in the discovery process. Simply put, because this information exists in cyberspace, it doesn't remove it from the basic discovery obligations.
What happens when a person selects to keep their social networking site private? Does that have any effect on the admissibility of evidence in a civil litigation case?
Well, courts have actually held that litigants cannot hide behind their self-imposed privacy controls on these social networking sites, where the entire purpose of the social networking site is to create information and share it with others online. A Canadian court put it very aptly when they said that Facebook is not a means by which people go online to have monologues with themselves. It's just not the purpose of these websites. In another case from New York called Roman v. Steelchase, in that case the court said that in the context of social media, litigants, if they have any reasonable expectation of privacy, it doesn't really exist, and it's more akin to a theoretical protocol that's called wishful thinking. So in sum, self-imposed privacy settings on these social networking sites do not trump basic discovery obligations.
Well, you've certainly clarified a lot dealing with social media. Do you have any other practice tips that you can provide to young lawyers?
As a parting tip, I'd just like to wrap up what we've discussed about social media and privacy. Now, I understand while people may be hesitant or more protective of information on social media because of the free-flowing and confessional nature of the medium, what they have to understand is that social media is really no different than any other kind of form of communication and discovery. It's just being put in a novel context, which is social media websites that many attorneys may not be familiar with. There's no exceptions in the Florida or federal rules regarding social media communications, and there's no special privileges that attach to social media communications. So in sum, really, any communication on a social networking website, if it's relevant to the claims and defenses in the litigation, is properly subject to disclosure and discovery, just as if the same communication were said to an acquaintance or a friend, that communication would be subject to disclosure in a deposition.
Thank you so much for joining us here today, Kat.
All right, thank you.